I mean, that's.
So your concept of reasonable time, it seems to me, carries with it some idea or consideration of the prejudice to the other side. Is that right?
Well, prejudice to the judgment creditor, and I just think you could reasonably take into account the burden on what Justice Sotomayor was saying about, did the person lack resources? I think that's certainly.
And notice.
Oh, yeah. So definitely, we think due process requires notice. Absolutely. We just think it's due process notice, which is actual or constructive. In other words, you can't hide and go, travel to the moon and avoid notice if the person is, doing all the things that the due process clause requires to give notice. But here, notice is conceded, I think, 6 times over because the trustee kept trying to do it.
Well, suppose somebody who's never left New York City, never traveled west of the Hudson, never done anything on the internet, never bought anything by mail, receives a judgment issued by a state court in Montana. And this person doesn't have a lot of money to hire a lawyer and says, what is this? I've never been in Montana. I don't know anything about this lawsuit. I never was served. I'm just going to ignore it. Wouldn't it be reasonable for that person to have more time to seek relief from this judgment?
Yes, I was trying to concede a lot with Justice Sotomayor, but I don't think Rule 60 applies to state judgments. I think you got to go to the state court.
District judge and district court for the District of Montana.
Sure, there might be a lot of reasons where there's just no reason. Like you got a default judgment, you hear about it. I mean, if it's worth a lot of money, I might get scared and call a lawyer. But if you have no reason to think, they're never going to come after me. But when you know someone's coming after you, you probably should act. But if there's no prejudice, we don't have a problem with, at the time of enforcement, loosely defined, which would be the judgment creditors trying to collect on the debt.